Well, all the attorneys on this case are pretty experienced, and we're used to volumes of evidence. The real problem here is getting the appropriate accommodations for either us or our investigators to go over the evidence with our client at the detention facility. That's the real challenge. You know, when you're limited as to time, when you're limited as to space, it can be really difficult to explain to them exactly what the nature of the case is. And that's the real mountain we have to climb.
And this SEPA thing, it might make it even harder. If you can't physically give evidence to your client, then that means you're going to have to be.
Well, SEPA really pertains to what evidence they give to us. The evidence we can't, you know, we've already pretty much agreed we can't give much of the evidence to our clients because a lot of it's classified. The SEPA evidence would be evidence which is highly classified, I guess is one way of putting it, where the question would be, do they have to turn it over to the defense at all? Is it relevant to a possible defense in the case? And that's a decision the judge makes ex parte.
How do you,
under the SEPA Act.
How do you defend someone when you don't see all the evidence? So.
Well, as is a part and parcel of the Patriot Act, you're right. We don't even really have a right. We don't even know what the evidence is unless the judge rules that it's something we can see. So as a result, not only can we not defend against the evidence, we don't even know it exists. That's the difficulty. And SEPA is a procedure that the Congress came up with to allow a trial judge to go through evidence to basically balance the defendant's right to a due trial versus national security interests. We don't know if there's going to be any SEPA evidence in this case. I suspect there will be, but we don't know that.